Okay. Well, good afternoon or good morning, depending on what time zone you are in. We would like to thank you all for participating in today's webinar. We'd like to take a moment for you to look at our sponsors and thank our sponsors. I would try to name them all off, but I would forget all of them. And I will just go ahead and get introducing our speaker, Shannon Farrell, who is an associate professor at Oklahoma State University who focuses in ag law. And he will be talking today about legal developments in animal agriculture, specifically focused on RCRA and the Clean Air Act, and maybe some other topics depending on how much time we have left. So I will just hand it over to Shannon and let him get started.
All right, good morning / afternoon to everybody. Appreciate everyone's showing up. We had tremendous registration for this event, so I'm glad to see everybody took the time out to listen to our presentation today. Thank you all for joining us. And like Paul said, we have a lot of sponsors to thank, so I will try to go through them pretty quickly, but like Paul said, there are almost too many of them to name, so thank you to all of these groups who have helped sponsor today's presentation. And I also want to extend special note of appreciation to the Southern Risk Management Education Center, because they have been very generous to support some of the research which we're actually presenting today. Some of the materials that we're going to talk about today with regards to the provisions of RCRA, the Clean Water Act, the Clean Air Act, are all issues that we're actually going to be talking about in a forthcoming compliance guide for farmers and ranchers on environmental issues. So stay tuned for that coming up here in just a few months. With that, let's get to the topic at hand. And when it comes to the topic today, you know, I kind of thought about SEALs when I was preparing this presentation, because SEALs obviously stands for Sea, Air, and Land, the Elite Combat Division of the Navy. And today we're pretty much talking about Sea, Air, and Land. The only difference is that we're talking about things in a little bit different order. Today we're going to talk about land, air, and sea. We build this as a RCRA and Clean Air Act webinar, but there was just a little bit of the Clean Water Act that I wanted to throw in there at the end. So we're covering all three of the major environmental media today. The first topic that we're going to talk about, and quite honestly, this is a topic we could talk about for the entire hour that the webinar is scheduled to last, would be to discuss the Cow-Pallas decision, which is based primarily on RCRA. So this is a picture of Cow-Pallas. And yeah, I am actually just kidding. Paul and I were recently at a conference in San Francisco, and Cow-Pallas is actually located on the outskirts of the city. That's actually where the Golden State Warriors used to play ball. Nope. Instead, what we're actually talking about is this Cow-Pallas and their lawsuit against a number of parties, including the Community Association for Restoration of the Environment and the Center for Food Safety. This is indeed an actual picture of the Cow-Pallas Dairy. It's located in the Yakima Valley of Washington. And as you can see here, it is located in a valley and is surrounded by vineyards. Viticulture is a pretty popular agricultural practice around there, as well as dairies. And we're going to talk a lot about Cow-Pallas just because they're the named party in the suit, but this lawsuit actually involved a cluster of dairies in the area. And so when we're talking about Cow-Pallas, just know that we're also including the other dairies that were parties to that suit as well. To give you a little bit of background on the Cow-Pallas operation, is what you would probably consider a large dairy. It fits the definition of a large AFO, if you're familiar with that, under the Clean Water Act. Basically 7,300 milking cows and the associated herd that would go along with a herd that size. There were an open lot pen setup, which again is a fairly common setup for lots of dairies. But what was particularly interesting about this case, and I think what probably drove a lot of it, was the fact that this is, again, like we mentioned, a dairy that's located in a valley, and that valley overlies a couple of aquifers, one of them being an alluvial aquifer, and the closest groundwater to the surface is between 30 and 190 feet below the grade here. So we had a pretty short distance between the surface and the groundwater aquifer, and I think that, again, drove a lot of the issues that we're going to talk about in this case. Now, before the decision that we're going to talk about was entered, and the decision that we're talking about is basically an order that was granted on motions for summary judgment between the parties, and we'll talk about what that means in a little bit too. There was actually a separate issue that was raised under the Clean Water Act, and specifically the Safe Drinking Water Act subset of the Clean Water Act, and that had actually been entered before this litigation started. A water quality study was conducted with EPA and the dairies starting in 2010, and then an administrative order on consent was issued in that matter in 2014. And part of that order was that the dairies would provide a safe drinking water supply to residents with wells that exceeded the maximum contaminant limits, MCLs, within a 1-mile radius of the dairy's borders. And that's not an uncommon remedy whenever you see a water contamination suit and there's a potential threat to the water quality for residential water supplies or public water supplies. Finding an alternative drinking water supply is one of the common remedies that you see there. The dairy were supposed to take further actions to control potential sources of nitrogen, and nitrogen was actually the constituent of concern. It was nitrate contamination of the groundwater that drove most of this administrative order. And so what the dairy was charged with doing was finding new and better practices to control nitrate infiltration into that aquifer. And part of that process was to establish a network of monitoring wells. And again, this is a pretty common remedy when you're talking about a water pollution case. What you'll often see the courts or the agencies do is create a network of monitoring wells around where the believed plume is located, so that you can not only monitor existing contamination, but you can tell if there's any transport of that contaminant within the aquifer, or if you've got it contained. You can also tell if levels are going up, down, or remaining constant. Another provision of the administrative order was to ensure effective nutrient management, and that was kind of meant as a preventative measure to prevent any additional nitrate from infiltrating the aquifer. So those were the provisions of the administrative order between Cal Pallas and the EPA. Again, all of these issues are based on the Clean Water Act, which is typically the regime that you think about when you're talking about potential pollutants emanating from animal waste facilities, because typically where you see the permitting of those releases occur is under the Clean Water Act's NPDES, or National Pollutant Discharge Elimination System. And by the way, I apologize if we throw a lot of acronyms around today. If environmental lawyers said everything rather than using acronyms, all their conversations would take 10 times as long. So hopefully we can kind of talk through those pretty quick. But back to our topic. Normally, large animal feeding operations, large AFOs, you also hear them called CAFOs or CAFOs, depending on how you pronounce it, concentrated animal feeding operations, those are regarded as point sources of pollutants under the Clean Water Act, and they're permitted through NPDES, and usually the NPDES permit will include permit limits and provisions about wastewater containment, wastewater disposal, treatment, land application of materials. Usually that all occurs under the Clean Water Act, but this particular case was filed under the Resource Conservation and Recovery Act, or RCRA. And so let's talk about that for just a little bit. This case was filed in the Eastern District of Washington. It was a district court case, so this wasn't at the circuit level. This was at the district level. And the orders that we're going to talk about today were issued on motions for summary judgment that came forth on January 15th of this year. Now, I know that for those of you that hadn't suffered through law school, that may be a little bit tough, so let's explain what summary judgment is really quick. And there are two ways that you can go with summary judgment. There's what we call a Rule 12b-6 motion, and then there's summary judgment. 12b-6 is when there is no set of facts that would allow the plaintiff to recover. You're thinking, great, what does that mean? Well, what that means is there's not a legal theory that would allow the plaintiff to win. In other words, there's not a law that would provide relief for the plaintiff, okay? Summary judgment is a way of saying we now know everything that we need to know about this case. In other words, the parties have both filed their evidence, they've both provided their briefs. There's enough factual overlap in what they've said that the court knows what the facts are. There's no longer really any disputed facts, and the court knows everything it needs to know. No need to go on to trial. We can decide everything right here. I noticed in the text box real quick that we're having some audio problems with some folks. If anybody can actually hear me, would you mind typing in the text box to let me know that I'm not just talking to myself? Otherwise, you're just seeing a really boring PowerPoint there. All right. Thank you. Aha. Somebody actually can't hear me. Wonderful. Thank you, guys. Okay, so we're talking about summary judgments and Rule 12b6 motions, which I know this is incredibly exciting stuff. This is all stuff you learn in civil procedure class in law school, which is one of those classes that's great to take a nap in. The judge granted the plaintiff's motions for summary judgment on this case, and the parties actually entered a consent decree on May 19th of this year, where basically the parties said, all right, we've got the judge's ruling, let's move on to remedying the situation, and we can kind of move on with life from there. And so we'll talk a little bit at the end of this segment about what that consent decree actually required Cal Palace to do. But let's talk about what the legal issues were in this case. First off, did the plaintiffs, the environmental groups, CARE and the Center for Food Safety, did they have standing to file this case? And standing's not a granted. You can't file a lawsuit just because you don't like something that's happened. You basically have to prove that you, or if you're an association, a member of your association, had some sort of actual damage occur to them individually. And the court disposed of that issue pretty quickly. They said, yes, indeed, these guys do have standing. Whether or not certain evidence was admissible. Anytime that you have a case that's based really heavily on scientific issues, you have a lot of the case that will revolve around what is actually acceptable scientific evidence. And in the interest of time today, we're just going to say, yep, all of the evidence that was offered by the parties was included. There was nothing in the ruling that excluded any of the evidence. And all that's basically saying is that, look, we believe that the experts that were offered were legitimate scientists. They had the credentials. They followed the appropriate scientific methodology. And we can trust the numbers that they came up with. What we're really going to talk about are issues 3, 4, 5, and 6 in this case. Issue number 3 was whether animal waste, whether over-applied to soil and leaked in the groundwater, is a solid waste. And by the way, as we go through this presentation today, if you see something underlined, that means it's a defined term under one of the statutes that we're talking about. So it's not just a word, it's actually a very legally significant word. So we have to figure out, could this animal waste be considered a solid waste under RCRA? Issue number 4 was whether the dairy's manure management practices, which included composting the manure, applying animal waste to cropland, and storage and settling of some of that waste in lagoons, whether that considered open dumping under RCRA. And open dumping is a defined term there as well. Whether manure management practices could cause or contribute to an imminent and substantial endangerment to public health and the environment. Now, I know that's a big mouthful, but that term also has some significance under RCRA, because for someone to proceed under the citizen suit provisions of RCRA, you would have to show that the practice that's been complained of is an imminent and substantial endangerment to public health and the environment. So those words have meaning in the context of RCRA. And last but not least, whether the parties are responsible parties. And the reason that term is underlined is RCRA defines responsible parties as having certain legal obligations to either engage in certain waste management practices or to be responsible for cleanup of waste that have been disposed of inappropriately. So let's take these issues in order. Issue number 3 was whether or not animal waste could in fact be solid waste. And that ties back to the issue that we were talking about of imminent and substantial endangerment, because for there to be a citizen suit under RCRA, you have to show that there's been basically an unpermitted disposal of solid or hazardous waste. Hazardous waste is another defined term under RCRA. So really, for there to be a lawsuit in the first place, we've got to have a solid waste. So let's talk about the definition of solid waste for a second. RCRA defines solid waste as this, and I hate to be one of those guys that reads you everything on a PowerPoint slide that's positively covered in text, so I'm not going to do it. What I'm just going to say is this is a pretty inclusive list, and as you'll see, it explicitly includes wastes from agricultural operations. And the thing that really highlight here is, number 1, that agricultural operations are explicitly included in the definition of solid waste under RCRA. It's been that way for decades. But I also want to highlight here the term discarded material. And RCRA treats discarded material differently than materials that are intended to be, for example, recycled. Okay? When we're talking about the disposal provisions of RCRA, we're talking about a material that has been discarded. And you're thinking to yourself, well, everybody knows what discarded means? Well, sometimes you do, sometimes you don't. We're actually going to talk about that topic here in just a little bit. Suffice to say, from all this text that you see on your screen, though, what we're really talking about is pretty much anything that is disposed. Anything that's disposed can be a solid waste, defined term, under RCRA, unless there is an exclusion that exempts it from that definition. So anything can be a solid waste unless it's excluded. But, sorry, by the way, here's the definition of disposed of. Has served its intended purpose and is no longer wanted. So it's kind of what you think about when you say disposed of, right? It's something that nobody wants anymore. That'll be important too. So when we talk about exemptions, there is very specifically an agricultural exemption to the definition of solid waste. Agricultural wastes, including manures and crop residues, that are returned to the soil as fertilizer or soil conditioners, okay? This exemption looms large in almost every solid waste case that you see involving an agricultural operation, because almost always we're talking about a land application of animal waste, okay? And so this exemption is very important, and it was meant to incorporate existing agricultural practices. You know, people have been applying manure to fields since we've had animal agriculture and crops in the same region. So this is a long-standing agricultural practice, and RCRA acknowledged that. So the question that you would have to ask and answer in any case where you were trying to allege that an agricultural operation was violating RCRA is you would have to prove that they were not operating within the scope of the exemption. And you say to yourself, well, okay, then anytime a animal operation applied agricultural waste to cropland, wouldn't it be within the exemption? And the direction that the court took in this case was to say, well, ordinarily yes, but what if they're not applying it as a fertilizer? What if they're applying it simply to get rid of it? And that's where the court went with this decision. What the court said was, if you're applying your animal waste to the crop at a rate that the crop could uptake, some people would call that the agronomic capacity of the crop, then you're fine. You're within the exemption that RCRA provides. But if you're applying manure and other animal wastes at a rate that is inconsistent with what the crop can uptake, that looks like disposal. You're not using it as a fertilizer anymore. Now you're just applying it to get rid of it. And that's, again, what you would have to find if you're going to get around that agricultural waste exemption under RCRA. You'd have to prove that this is a disposal. It's not being used as a fertilizer. And that's where the court said. They said there's evidence in the record that supports the fact that the dairy wasn't paying attention to their nutrient management plan. The Dairy Nutrient Management Plan, DNMP, is the acronym that you see there. They weren't paying attention to that. They weren't doing proper soil sampling to determine what the soil's levels of nutrients already were. And if you're not paying attention to those two things, and you're not paying attention to what the crop is removing in terms of nutrients, then you must be applying it out there just to dispose of it. And so that's how the court got over the exemption barrier and found that this actually was considered to be solid waste. Furthermore, they also found that material that was leaking from lagoons and infiltrating groundwater, or from materials that were infiltrating into the soils from the composting areas, they also found those to be solid wastes. And the dairy's objection to that finding was, hey, we never intended to dispose of that stuff. That was just in a storage area and it happened to get away. And the court cited a couple of Ninth Circuit cases that said, well, sometimes when you put something in a storage area and you know or should have known that it was going to get out, if you had a reasonable expectation that that material was going to escape, then you consider that disposal as well. And so that was an interesting point for the court to make. All right, well, let's go on to issue number 4 now. And so issue number 4 was whether that waste could be, oh, I'm sorry, there we go. Whether we could have open dumping in the context of these disposal practices. So if you go back to the language of RCRA, anytime that we dispose of a solid waste in some place other than a permitted landfill, then it's basically considered open dumping. And you know, this is a provision that's been used to clean up tons of sites across the United States. I know here in our own state of Oklahoma, we have a huge problem with tire disposal. We see lots of tires thrown into ditches alongside the road, and people say, oh, we're trying to control erosion. Our environmental agency says, that's great, that's not a permitted landfill, that's open dumping. So we've got to have a solid waste, which we have already established, that's what we've got. And then if there's open dumping, that means you're applying the waste into a facility or area that's not considered a sanitary landfill that's been properly permitted under RCRA. Now, a solid waste disposal facility is defined by the regulations that support RCRA, and those are facilities that don't violate the criteria required to provide for environmental protection. And one of those criteria is that a solid waste facility cannot contaminate an underground drinking water source that exists beyond the boundary of that facility. Okay? That's important language for us to remember in this case. And what the court found here is, again, that there had been disposal of a solid waste, we established that definition, and that had caused groundwater contamination beyond the boundary of the facility. In this case, it was the dairy. And if you read through the order, you'll see that the court cites a lot of the groundwater sampling, and in fact the groundwater sampling evidence, not surprisingly, was a huge issue in this case, and its admissibility and its validity. But the court said, hey, we've got a lot of evidence that supports that there is nitrate contamination of this water. We feel that there's adequate evidence that supports that those nitrates are coming from the dairy. Therefore, you've violated the provisions of what a acceptable solid waste disposal facility would be, and thus you've got open dumping. Well, that takes us to issue number 5. Issue number 5 was whether there were any waste management practices that caused imminent and substantial endangerment to public health and the environment, which pretty much just tracks the language of the statute. And we kind of referred to this a little bit earlier. A citizen who's been damaged by inappropriate waste management practices can apply to file as a citizen to bring about enforcement of the RCRA provisions. Now, there are several loaded terms here that we have to talk about. For example, what's an imminent endangerment? Imminent says you don't have to have actual harm occurring. There just has to be a fairly reasonable certainty that harm will occur. Endangerment, meaning it has to be substantial when it's serious. And I'm pretty sure this is why there are lawyer jokes, because we do stuff like define substantial as serious, which you're thinking to yourself, wow, that's pretty tough. Last point to make here, substantial endangerment doesn't mean proof of actual harm, but threatened or potential harm. So when we're talking about imminent and substantial endangerment to public health, what we're really talking about here is, was there a immediate harm, or was there a almost certain harm coming this way? And the way that I explain this to my law classes is, if you've ever seen a Wile E. Coyote cartoon, and Wile E. Coyote is standing on the desert floor as an anvil is heading his way, he can see the shadow growing larger and larger around him. That's what I would call imminent, when it's pretty certain that the harm is going to come, even if the harm hasn't come yet. Oh, as I look over into the chat box, I see a question. One of the questions was phosphorus an issue in this action? I don't recall seeing any references specifically to phosphorus in the order. Most of the case was centering around nitrate contamination, and so that's where a lot of the evidence that was discussed centered. But they made a number of mentions of the nutrient management plan overall. And I know with certain waste, for example, if you're talking about poultry waste, lots of times phosphorus is a constituent of concern there. Lots of times when you're talking about livestock waste, you're talking more about the nitrates being a constituent of concern. I don't recall them mentioning phosphorus specifically, but they did mention that all of the nutrient profiles were kind of at issue, and that there needed to be better adherence by the dairy in doing actual calculations, both in the content and, sorry, I should have said calculations. I should have said measurement. Doing actual measurement of the constituents in the waste as it was applied, running soil tests and getting those results back, and then doing the calculations on historic data to the dairy about nutrient uptake from those crops. So lots of times when you've got an overapplication of nitrogen, sometimes if you're not watching, you can also get an overapplication of phosphorus, but they didn't specifically bring that one up in this case, if I recall correctly. When it came to issue 5, was there an imminent and substantial endangerment to public health and the environment? The court said yes, there was, and the primary evidence they relied on of that was the ongoing drinking water sampling that had been done in the area, and they found that several of the residences in the area had their drinking water wells exceeding the MCL levels, again, that maximum contaminant level for nitrate, and that was the limiting concern on this one. When they crossed that nitrate threshold, that's kind of what the court relied on to say, yes, there is an imminent and substantial endangerment to public health and the environment here. Last, issue number 6 was whether the dairies were responsible parties as defined under RCRA. And basically what you have to show to find a party as a responsible party is the fact that they had some sort of culpability in the disposal of the waste that's at issue. And that's, mainly a causality issue. RCRA doesn't want to hold people responsible if they really had nothing to do with the application of the waste or the disposal of the waste that led to a particular environmental concern. And so this is establishing kind of a causality requirement. You have to show that the parties were actually responsible for disposal of the waste or had a measure of control over the party that was responsible for the disposal of the waste. And here the court said, yes, these guys are indeed responsible parties. So, pretty much all of the issues brought about were found in favor of the plaintiffs in this case. Were the plaintiffs actually capable of bringing this lawsuit? The answer was yes, they did have standing to bring that. Number 2, was the evidence admissible? In other words, were all the expert testimonies allowed in and all the sampling data? And basically the court did admit pretty much everything, so yes, it got in there. Whether animal waste, when overapplied to soil and leaked in the groundwater, is a solid waste, and the court said yes, if it is being overapplied, meaning it's not being applied in synchronicity. Wow, I almost made a word there. If a waste is being applied and that's not being synchronized to the uptake of that crop, that could look like a disposal rather than a farming issue. And so they said, yep, it was. Issue number 4, whether the dairy management, the waste management practices constitute open dumping, and those again included use of those open compost piles that were unlined, by the way. The composting was occurring on bare soil, basically. The storage of the materials in lagoons and the application of those wastes to the fields, all those were considered to be open dumping by the court, so yes, they did. Whether manure management practices caused an imminent and substantial endangerment to public health and the environment, the court concluded that they did, and whether the dairies were responsible parties, they concluded that they were. Oh, real quickly, as I look over the chat box, we had a question about whether there's an imminent and substantial danger to human health. And the answer to that is there are 2 key provisions there. One is human health, the other one is the environment. The way that RCRA is worded, it says substantial and imminent danger to human health or the environment. So it's not necessary that you would show that there would be a human harm element if you could show sufficiently that there was going to be environmental damage, natural resource damage occurring as a result of the practice. Now, as a former private practice attorney who practiced in the environmental field, what I'll tell you is that human health gets people's attention way faster. And here you were talking about nitrate toxicity and exceeding the MCLs for nitrates in groundwater. And there were the primary health concern of nitrate contamination, or at least the one that's the most sensitive receptor, is children. Children and infants can have a very serious reaction if they ingest too much nitrate, in that it will interfere with the efficacy of the hemoglobin in their blood. You may have heard of blue baby syndrome, and that's the reason that we have MCLs for nitrates. There are obviously effects that can be had for adults as well, but infants and children are the most susceptible to that. And so that's really the issue, is human health or the environment, which actually I think answers the question right there. It is or human health or the environment. Also had a question there about upgradient and downgradient testing, and the answer to that was yes. the monitoring wells, both under the administrative order on consent and for the evidence gathering of this particular trial, included monitoring wells that were up the groundwater gradient from the dairy, actually on the dairy facility itself, and down gradient from the dairy. And you know, we talked about the fact that the judge admitted all this evidence. That's not to say that all the evidence that was admitted wasn't controversial. There was a lot of disagreement about the testing methodologies, well locations, any potential pre-existing nitrate plumes that might have been in the area, because this was an area that had been used for agriculture for quite some time, and that was one of the dairy's contentions, was that there really wasn't a good enough causality link to determine that this was nitrate that they had introduced into the aquifer, which I found a little bit surprising, by the way, because the court specifically stated that, look, we don't have to do a molecular trace to determine that these nitrogen molecules came from the dairy or not. I've actually seen other cases where the court has actually admitted that sort of evidence. There are a few nitrogen isotope tests that can be run to show whether or not nitrates came or likely descended from animal waste applications versus, for example, commercial urea applications. Those two things have slightly different isotope profiles. So, you know, I was kind of surprised that the court found that there were no material issues of fact in this case, because given as much discussion as they devoted to the controversy of the collection efforts, you know, I thought they might have found that there was an issue there. Let's see here. We got a few more questions here. I'm just going to scroll back up to the text box real quick. A good baseline inventory is essential. Absolutely. Every time that I talk about environmental issues in agriculture, I tell everyone, the better your baseline data, the better your case. So if you're about to start an operation of any type, if you're about to drill an oil well, sink a groundwater well, or start an animal feeding operation, I always encourage everyone to do a very thorough, well-documented round of baseline testing using a state-licensed lab and maintaining full chain of custody documents so that you've got a very good evidentiary case set for what the baseline of the area was. And you know, in talking in another context of RCRA and CERCLA, there's actually a provision called an all-appropriate inquiry evaluation of the property. Basically, you do an environmental assessment of the property before you buy it so that you can prove to the environmental agency with jurisdiction, hey, when I bought this thing, it was clean. So I went into this, you know, knowing what I knew. Or, alternatively, before I bought the piece of property, there was contamination there. I didn't do it. That was there when I got there. So that's another important thing. I think baseline data is hugely important there. I'm scrolling down to some more questions here real quick. Let's see here. Did the dairies have CAFO permits, and would permits affect the issue? That's a great question. I'm going to hold discussing that one for just a little bit, because that's a great question. It may be an even better question than you thought when you typed it. We are going to talk about that. How are emissions of solid waste regulated by RCRA handled by the body of laws and regulations? That's going to kind of go along with our CAFO permit question. I'm going to hold off on that one for just a second. Let's see here. All right, I think we kind of got everybody taken care of for the moment. I want to talk about just a couple of follow-ups here. Like we said, the parties in this case entered a consent decree on May 19th of this year. And some of the provisions of the consent decree included that the EPA was going to be authorized to engage in basically a sampling and inspection program with the dairy. And it also required that as part of that, the dairy was going to have to step up its efforts on nutrient application record keeping. One of the issues in the case, which we'll talk about here in a slide or two, was the fact that they were keeping some records, but they were using guidelines provided, you know, understandably so, in their permit with the Washington State Agency, but they were relying on baselines and not actual measurements and calculations. Another issue was that the lagoons storing waste on the property had to be redesigned and rebuilt to include synthetic liners to prevent any sort of infiltration of the waste from the lagoons to the groundwater table. There was going to be a larger suite of monitoring wells, and the consent decree actually explicitly looped that into the previous administrative order on consent that had been filed under the Clean Water Act and the Safe Drinking Water Act provisions. So those two are now linked together there. The dairy was required to continue its efforts to provide alternative drinking water sources to anybody who was affected by a defined area. And if I recall correctly, I believe that the defined area was a mile perimeter around the border of the dairy, if I recall that correctly. On a more innovative front, the dairy was going to be required to install a centrifuge manure separator to kind of, again, provide an advanced means of nutrient management for the system, and was also going to have to do a pilot project on aerated composting to make sure that there was better breakdown of the soil nutrients before they were actually allowed to infiltrate the soil there. Now, a couple of things I kind of wanted to take away beyond just what the court ruled on with respect to those 6 issues that we talked about. You know, and I see this all the time, and I can't overstate how important this is. Those nutrient management plans are critical, and that's actually one thing that the court looked to. And if you see this text here, for example, defendants contend that Cow Palace's general manager engaged in a series of calculations when applying manure to the dairy's fields. Considering the manager's declaration as well as his deposition testimony, it's clear that characterizing his practice as engaging in a series of calculations is a stretch. You never want to hear that from a judge when they say, well, you said you were doing this, but you really weren't. And the reason that the court cited that was, number one, like we talked about a second ago, the dairy, at least according to the evidence, you know, and all I really have to go on is what the court had in the record. The dairy was using guideline rates for nutrient application rather than using actual soil data, using actual harvest data to calculate how much of a given nutrient the soil could take. And the court really came down on them for that, and understandably so, because that's kind of the linchpin of the whole statutory scheme here. They also got knocked for testing the waste that was applied, the effluent, from a central lagoon rather than the lagoon they were drawing from. And if you read the testimony in the case, it says that if you look at the facility, there was a central lagoon, and that lagoon would then be drawn from, or would have other secondary storage lagoons. They believed that the nutrient profile from the samples in the central lagoon would be representative of the other lagoons. And what the court dinged them for on that was to say, that's great, but why didn't you draw a nutrient sample from the specific lagoon that you were drawing from to make that land application? They also, at least according to the record, didn't test for the soil residuals. In other words, they didn't do a soil test before the application to see how much nitrogen, how much phosphorus, how much potassium was already in the soil before they made the application. And the court really loops to that when it talks about finding that this was a solid waste. Let's go back a little bit in the presentation and remember, animal waste applied as a fertilizer is not a RCRA solid waste. To prove that that would be a solid waste, you have to show that it was disposed of, remember, defined term, versus used as a fertilizer. And so if you're applying a material without regard to the crop's uptake ability, that's when it really starts to look like disposal. I mean, for example, if you go to the oil patch, lots of times they will use a land application method to dispose of some oil wastes because soil microbial activity will break down the hydrocarbons in the oil material. But they're not applying that with any intention of basically serving it as a fertilizer, okay? That looks like a disposal, and it's actually regulated as a disposal process. Not so here. So not paying attention to the soil residuals really got the dairies in trouble here. And that loops to the next point right there, where they applied waste when the soils had plenty of nutrients already in place. So, I think one takeaway for animal livestock operations to get from this ruling is those nutrient management plans are so important. And it's not just enough to have a plan. You gotta follow through with it. You have to actually do the waste testing. You actually have to do the soil testing. You have to do the calculations of what the crop can actually remove in terms of that nutrient. You got to treat this stuff legitimately as you would a commercial fertilizer that cost you, perhaps a few $100s a ton, okay? So, nutrient management plans, hugely important. You know, another thing that I found really interesting about this case was the discussion that was devoted to the lagoons. And that was another topic of really controversial evidence because there was a lot of disagreement, if you read the record, about exactly how much of the effluents were leaking from the lagoons. And part of the problem that the dairy had here from an evidence standpoint is that they really didn't have a good as-built diagram signed off on by a certified professional engineer about how the lagoons were actually constructed. The best they could do is show that the designs called for a compacted layer that was supposed to be less permeable, but they really didn't have any evidence to show that's actually how the lagoon was built. And that's a really tough evidence position to be in, because otherwise the only way for you to prove that your lagoon has a liner would be to actually test the liner. But in testing the liner, you've now punctured it and created a leak in the lagoon. So I think another takeaway here then would be to say, okay, as you're building a lagoon, make sure that you've got a good as-built diagram signed off on by a professional engineer so you can show, yes, this is actually what was constructed. Good monitoring well setups are always a good idea around that as well. And especially when you're in an area that has a very shallow groundwater aquifer. And many states, and to some extent EPA under the Clean Water Act, have design provisions that talk about depth to groundwater and improved liner construction, which might be either a synthetic liner, as you might think about a synthetic plastic liner that lines the lagoon, or you might see a compacted a compacted clay liner. And compacted clay has to be tested to show that it has a certain permeability. In other words, a fluid will only pass through it at a certain rate before it can be certified. Other things to think about here is the fact that just because it looks like a waste problem doesn't always mean that it's a waste problem. And sometimes when you really panic about an issue, maybe on closer examination it's not as bad as you thought. And I'm not opining as to the environmental issues specifically with Cow Palace. There's been a lot of discussion about the impact of this decision and what it has not only for RCRA but for animal waste facilities across the nation. And to that, I'd make a few observations. Number one, as of right now at least, this is an unpublished case. And you're saying, so what? For a case to have precedential value to other courts, it has to be selected by the court of jurisdiction for publication. And at least as of now, this case has not yet been published. So this is one decision on a summary judgment motion in one case in one district. So at least as of right now, this case doesn't have precedential value for other courts. Now it may, and we'll know that within a few months, but at least as of right now, it can't really be relied upon as authority for some other court. Another thing is that we've seen lots of cases in the animal waste context try to follow the same line of reasoning that we saw here, that the over-application of a waste is a RCRA disposal. But it's interesting as you read through the case that the court doesn't cite any cases saying that, yes, other courts have found that under RCRA, animal waste can be a solid waste. And that's because there isn't any. Lots of cases have gotten to this point, specifically this point where we get to motion practice and we're filing these motions for summary judgment. You've got the rulings of the evidence, the case gets settled, or there's a motion on summary judgment and the case is resolved, and it never goes to an appeals court where you have a publishable opinion. So this is still a theory that's being advanced, in lots of cases, but it's not precedential yet. And then, of course, as a former law student, I have to observe that this came out of the Eastern District of Washington. Washington is a district court in the Ninth Circuit, and the Ninth Circuit is the most reversed circuit in the federal system. So sometimes you have decisions that come out of the Ninth Circuit, sometimes they don't make it very far beyond that. Now, I want to go back and loop to a couple of really good questions that our attendees asked about the permitting issues. Did these facilities have permits? Would that permit have affected anything? Here's the deal. Permits for CAFOs or CAFOs are issued under the Clean Water Act's NPDES system. They're issued as water pollution permits, and they're based on a point source of water pollution, that point source being the defined borders of the animal feeding operation. And that's really been set up to deal with the kind of issues that we're addressing here, because if you peel away the layers of the onion in this case, it was a case brought under RCRA, but it was really about water contamination. And so that's where you kind of get into some fuzzy jurisdictional areas here, because really RCRA, the Clean Water Act, the Clean Air Act are all about overall protection of the environment, but they only work within their specific media. And so this is a really tough question, and I think some courts would look at this facts and say, hey, you brought this case under RCRA, you brought it under the wrong statute. What you should have done is brought it under the Clean Water Act. And oh, by the way, this dairy already had an administrative order on consent that said the things they were supposed to be doing in terms of nutrient management, wastewater, water monitoring, and all those sorts of things. So I think there's a really distinct jurisdictional issue that the courts would have to decide here. And number two, if this facility had a CAFO permit, and I admit that the case doesn't really talk about that, but I've got to presume that they did have a CAFO permit. You know, you could argue that if you were adhering to the permit provisions, you should have had what we call in environmental law as a safe harbor. Hey, I was doing everything the permit required me to do. I really should be immune from prosecution if I'm doing all that stuff. And again, I'm not going to opine here about whether or not Cow Palace was doing everything they were supposed to do. The record seems to suggest, at least in some regards, they probably weren't. But in response to that, you know, to have a CAFO permit provides you at least a little bit of a safe harbor if you're adhering to the permit and following all of its requirements for best management practices. That's Cow Palace, and that's land. Now let's talk about air issues for just a second. And I notice that we now have, wow, 13 minutes to talk about the last two topics. I will go pretty quick here. There's a current case pending that's not really about any specific operation. This is actually more of an administrative procedure issue, which I know everyone is super excited about. Everyone loves to talk about administrative procedure. But this is the case to basically compel some sort of forward motion when it comes to an EPA proposed rule about air emissions reporting for large animal feeding operations. And again, here we are, we're talking about air emissions, but we're talking about it in the context of CERCLA, which most of you know as the Superfund law that deals with the cleanup of hazardous waste, and the Emergency Planning and Community Right to Know Act amendments to CERCLA. CERCLA deals with the cleanup of releases of hazardous waste. In other words, RCRA tries to prevent releases from happening by mandating proper disposal and handling of wastes. CERCLA deals with what happens when that release has already occurred. Now, a subset of that is IPCRA, and IPCRA is a means of trying to provide federal, state, and local authorities with a means of rapidly and effectively responding to a release. And part of the provisions of IPCRA are that if there's been a release of a hazardous substance, it has to be reported. Now, there is a list of lists. Believe it or not, there actually is a document called the List of Lists that contains a couple of thousand of materials that, if released, there has to be a report made to the federal, state, and local authorities. Two of the things on that list are ammonia and hydrogen sulfide. And ammonia and hydrogen sulfide are materials that can be released when we have the aerobic or even anaerobic processing of animal wastes. And the reportable quantity for that release is if you've released 100 pounds or more of that constituent, in this case ammonia or hydrogen sulfide, in a 24-hour period. And most of the time, when we're talking about that, it's perhaps from a leaked facility, or we have a container that's ruptured or something like that. But what we'd be talking about in the context of animal agriculture is the fact that we may have a multiple acre lagoon that's very slowly emanating these materials at a very low concentration. There's probably lots of atmospheric mixing going on, and so it's not the traditional kind of release that you'd think about either under CERCLA or IPCRA. Now, another thing that really makes this difficult is knowing whether or not you've had a release of 100 pounds of ammonia in a 24-hour period, because what we're talking about is a non-point source. If you want to measure how much carbon monoxide is being given off, or hydrogen sulfide or any other constituent from, say, for example, a power plant. You've got a pretty defined and discrete exhaust port where you can insert a probe and measure the flow and number of the particles moving past your probe to determine that amount. That's really hard to do in a non-point situation like a lagoon because there's no place to really stick the probe. And so what you have to basically do is you have to come up with emission factors. You have to basically do the chemistry and try to back calculate how much of this material do we think got released, knowing what we know about the chemicals that are present and the quantities in which they're present. So that's really hard to do. So go back then to the year 2005, EPA realized that there was a potential issue with air emissions from animal waste storage facilities, and specifically, they were looking a lot at open lagoons, and they said, okay, we're going to issue a consent order, basically saying, hey, if you want to come and sign on to this consent order, animal operations, you'll be immune from prosecution. You may have to pay a penalty based on your size, but that will resolve the issue, and you agree to participate in our study so we can get better emissions factors. In 2008, EPA issued a rule that exempted farms, again, underline, defined term, from CERCLA and IPCRA waste reporting. And the rule said that all farms were exempt from reporting to the Federal Response Center, the National Response Center, and anyone under the large AFO thresholds, basically, was exempt from reporting to local and state agencies. And lots of you guys have probably already seen it, but we'll throw it up here again just for the sake of refreshing your memory. These are the thresholds for large, medium, and small CAFOs there. So anybody under a large AFO threshold basically was exempt from all reporting under CERCLA or IPCRA. That didn't sit well with some environmental groups, though. They said, hey, there's really not a compelling reason for us to exempt these facilities, so we want you to go back and review this rule. EPA asked the court to remand the rule back to them, and they said they would reconsider it. And the court said, yeah, that's fine, go back and reconsider this rule. And part of the reconsideration was that they were proceeding with what was called the National Emissions Monitoring Study, NEMS, to create final emissions estimating methodologies, EEMs, to provide a better set of guidelines to calculate what the emissions would be from a lagoon, again, given its configuration, its operation, et cetera, et cetera. December 2012, draft EEMs came out for certain types of animal operations, but EPA didn't take any measures to actually finalize those draft rules, and those draft rules were themselves the subject of a lot of scientific controversy. And then really nothing happened on that front. There weren't any proposed or final rules issued by EPA, and things were fairly quiet until April 2015, when the petitioners in this case filed a motion to recall the mandate in which the court had said, yes, EPA, it's okay, you can take these rules back to reconsider them. And what the petitioners asked for was either, one, pull back the mandate. In other words, let's move forward with this case and brief it on the merits. In other words, let's actually talk about, was this rule valid or not? Or, number two, court, issue what we call a writ of mandamus, which is, again, lawyerese for make this agency do what it's supposed to do. A writ of mandamus is basically an order from the court that says, agency, you're not doing what you're supposed to do what you're supposed to do. That's proceeding a little bit. The parties have actually talked about briefing the case on the merits, and they've actually entered into a scheduling order to kind of work on that. And under the scheduling order, I think the briefs would start in October, and the final deadline would be in January of 2016. Things that I kind of want you to take away from this particular case is, number one, that there's really nothing to take away yet. This case is still very much in its infancy, even though it's been going on for 5 years. Another issue is that this is technically an incredibly difficult area. It's really hard to get concrete numbers about non-point sources of air emissions. It's just scientifically darn tough. And this actually loops back to the Cow Palace case, where, remember, we had a water issue that was being addressed with through the solid waste statute. Well, here what you've got is an air emissions issue that's being attacked through the hazardous waste disposal and release statute. I think what we're going to see over time is that there might actually be an air emissions permitting system for animal production facilities that have area sources, for example, things like lagoons, treatment, containment areas, things of that sort. And I think that you're going to have to see those things regulated with a system that we use in air called regulation of fugitive emissions. Fugitive means that they don't come from a specific point. They kind of leak out from areas that you really can't define or control. That day may be coming, but I don't see it coming quite yet, just because the science isn't there yet. That's the whole reason that I think we really haven't seen much motion on the rules front with air reporting, is the fact that it's really just hard to get your hands around what those emissions actually are, and that's not going to change at least for a couple of years. Last topic, and we're about to run out of time, is to talk about water issues, even though that's what we've already talked about, just with a different statutory system. So let's talk about the Clean Water Act, and you can't talk about the Clean Water Act without talking about the Waters of the United States rule. Everybody's favorite telenovela when it comes to environmental law here in the past couple of years. I've seen a lot of histrionics about environmental issues, and I'm not sure that I've ever seen histrionics like those that have surrounded the proposed Water of the United States rule, which, by the way, isn't new. It's new in the fact that EPA has been trying to codify it, and the Corps of Engineers as well, into regulations. But we've had this rule since the Rapanos decision, which I think was back in 2007, when Justice Kennedy issued his opinion in that case, and that's basically kind of been the law of the land since then. So lots of drama here, lots and lots of drama. The rule actually went final in June of this year. So it's actually been issued as a final rule. Its effective date won't come until later this year. But, right, that person that you thought was dead in your favorite soap opera isn't dead. They were just shipwrecked, and now they've showed back up. On July 30th, 2015, the House Committee on Oversight and Government Reform released a bevy of internal memoranda from the U.S. Army Corps of Engineers. And in those documents, the Corps of Engineers are slinging a lot of arrows at EPA about how they don't like the development of this rule process. And environmental groups have seized on the fact that the Corps of Engineers had some real problems with the environmental analysis that EPA undertook, and that they don't feel like the rule fully takes advantage of the jurisdiction EPA and the Corps had under Justice Kennedy's opinion. On the other side, lots of agricultural and industry groups have seized on the fact that the Corps slammed the economic analysis of the rule that EPA performed pretty hard. And so both parties have kind of used this as a means of renewing their calls for the rule to be recalled. And let's tell you, it's been pretty kind of crazy. The environmental groups think the rule is terrible for this reason, the industrial groups think the rule is terrible for this reason, and I think there's a couple of potential outcomes here. Number one, EPA could say, yeah, you know what, we're right, there's a problem here, we need to go back and redo the NEPA analysis for this rule. And that may be what the environmental groups want, but I'm not sure it's what the environmental groups want. Because if you go back to NEPA review, you run the risk of completely resetting the rule and starting all over. On the other hand, what you could have is Congress saying, look, you guys can't get this rule right. What we need to do is modify the language of the Clean Water Act to provide a definition of waters of the United States, because that's been the problem all along. The Clean Water Act never defines what waters of the United States means, and so there's been a lot of judicial interpretation, and that's what's led us to where we're at today. So it's pretty funny, and what we're really going to see, I think, move the needle is on August, let me switch back my slide here just one second, I believe August 28th, there we go. August 28th is the effective date of the rule. As soon as we see somebody actually impacted by this rule, and I'm not sure we actually would see that immediately, but as soon as somebody is impacted by an adverse determination under this rule, then they're going to have litigation standing to pursue vacation of the rule in a federal case, and we'll see all this writ large again. So very interesting, as always. With that, I have babbled the entire time that we had allocated for the webinar. I tried to keep up with the questions that we had in the text box as we went along, but real quickly before we wrap up, does anyone else have any questions that we can talk about before we wrap things up for the day? Going once, going twice. Oh, I see multiple attendees are typing. I'll wait for just a minute here. Paul, while we're waiting for anybody to type in questions, would you like to give any plugs for some of our upcoming webinars?
Not at this point. I can't think of any that are coming up. We're going to kind of slow down at this point and probably start some back up later in the winter. Late fall.
Excellent. Very good. Well, gang, we had some excellent questions. Thank you for everybody that signed up. Thank you for your questions. They were.
I will get those uploaded online later today and send it out with a link to the webinar, or a link to the recording of the webinar later this afternoon, hopefully. If not this afternoon, it'll be early tomorrow morning.
One quick note from the text box, Josh Spencer, I think had an excellent observation. Follow those nutrient management plans, document compliance with agronomically based crop applications. I think that's
for participating today, and for those that are still on, the evaluation is down, and I will send that out as well because Shannon would really like to probably be evaluated on his topic today.
I always love a good evaluation.
Shannon, and thank you for everyone attending.
Thank you all. We appreciate it.